Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have our final webinar for 2021, and not to worry, we will be conducting webinars next year, but our final webinar of 2022, an overview of Arizona's Prompt Pay Act. So without further ado, I introduce the fabulous Kevin Estevez.
Thanks, Ariella. All right, today we're going to be talking about Arizona's Prompt Pay Act. And if during the course of the webinar, if you have any questions, use the chat box on the right, and we'll take any and all questions you have at the end. We ask that you please do not include names, company names in the questions. So before we get started on the Prompt Pay Act, I'd like to just do a quick refresher of what we've done this year. We've covered a lot with respect to Arizona construction law. The first webinar was on Arizona's preliminary 20-day notices, lien and bond claim refresher with pro tips. Our second webinar was what happens after I record my mechanics lien in Arizona, how do I get paid? The third webinar was on lien waivers in Arizona, be careful what you sign. The fourth was on bad checks and credit card chargebacks, how to deal with them in the context of construction debts in Arizona. And webinar number 5, the last one we did, was dealing with bonded liens, i.e. lien discharge bonds in Arizona. And we also covered recovering on public project payment bonds on that seminar as well. So we've covered a lot. Most of what we covered relates to lien and bond claims in various ways. Today we're going to talk about another tool that Arizona contractors have that is somewhat unique to Arizona. I know other states are developing similar statutes, but Arizona has really been at the forefront of having a Prompt Pay Act. And so with that, let's jump right in to talk about Arizona's Prompt Pay Act. Arizona has really two different sectors of prompt pay laws. We have a host of public sector prompt pay laws that are the same, but can be found in different places in Arizona's revised statute depending on the type of public work that one is doing. And we also have private sector prompt pay laws. And we'll talk about both, but I'm going to spend most of my time today talking about the private sector prompt pay laws. So as I said, Arizona has both private and public sector prompt pay laws. Arizona's public sector prompt pay laws can be found in 3 different areas within our statutes, depending on the type of work being done and the ultimate client for the project. ARS 28-6924 is the prompt pay statutes relating to work done on Arizona Department of Transportation projects. ARS 41-2577 is the prompt pay statutes related to work done on state projects generally. And finally, ARS 34-221 is the prompt pay laws that apply to city, county, and improvement district projects. And so these are the statutes that govern public construction projects, and we'll get into in a minute what makes those different from the private sector and vice versa. Arizona's private sector prompt pay laws can be found at 32-1181 et sec, and these govern private construction projects lasting more than 60 days with the following exceptions. So number 1, first exception, it only applies to residential construction, and that is owner-occupant project, if the contract with or the invoices to an owner-occupant contain notice that the prompt pay laws apply. And another exception is the parties can alter the billing cycle by number 1, providing for a different payment schedule in the prime contract in a clear and conspicuous manner, and placing a statutory notice of alternate billing cycle on every page of the construction and bid plans. And the reason for this, for a fundamental level, is if you want to opt out of the prompt pay statutes, If the owner and the general contractor elect to do that, it may not funnel down to everyone on the project. And so as a statutory mechanism to make sure everyone is aware of what's going on, Arizona statutes require that there's clear and conspicuous language in the prime contract, and that this notice of alternate billing cycle is placed on every page of the construction and bid plans, so that the folks who may only see portions of those plans, the mechanical guys see the mechanical plans, and if they see those, they know that a different billing cycle is being applied on the project. So the goal behind that is really to make sure that everyone's aware that the typical prompt pay 30-day billing cycle may not apply and can adjust themselves accordingly. So this is the standard, I apologize, jumping in here. This is the standard billing cycle on public projects. First, the owner receives the general contractor's invoice and has 7 days to review and approve it, and then 14 days to pay. And once the general contractor receives payment from the owner, they have 7 days to pay their subs, and then those subs in turn have 7 days to pay their suppliers and any subcontractors. So the idea is basically that you have a 30-day billing cycle wherein the owner receives the general contractor's invoices, has 7 days to review and approve, pay within 14 days, and then make payments to the general contractor. Then it makes payments to its subs within 7 days. So that gets you to about 28 days and the 30-day billing cycle. This is the standard billing cycle on excuse me, 1 second. Oops, there is a typo in the heading here. This is the standard billing cycle on private projects. I apologize for the typo in the heading. On private projects, the billing cycle is a little bit different. So whereas on a public project, the owner has 7 days to review and then 14 days to pay, it's the inverse on a private project. On a private project, the owner has 14 days to review and approve an invoice or a payment application, and then 7 days later to pay. But with respect to the payments to the folks downstream on the project, the payment cycle is still the same. Once the general receives payment from the owner, they have 7 days to turn around and pay their subcontractors. And with subs, they then have 7 days once they receive payment from the general to either pay their suppliers or subcontractors. So the big wrinkle between the public sector and private sector prompt payment laws with respect to timing is in the amount of time that the owner has to review and then pay the invoices of the general contractor. And again, on public projects, it's 7 days to review and 14 days to pay. On private projects, it's 14 days to review and then 7 days to pay. And again, I apologize for the typo on this slide. So what are the key provisions of Arizona's private sector prompt pay laws? Number one, as I just mentioned, it sets up a 30-day billing cycle and puts requirements in place to make sure that folks that are performing work on a project are in fact being paid in a timely fashion. That works out to about 30 days. The second is, again, on the private sector projects, the owner has 14 days to review and approve the general's pay application, and then 7 days later to pay. And then, as I said last slide, the contractors and subcontractors pay their subs and suppliers within 7 days after receiving payment. Owners, contractors, and subcontractors can refuse to approve and certify a subcontractor's or supplier's invoice for payment by objecting in writing. And that's really important, and we'll get to that in a second. And then also, a key component of the prompt pay statute is that sums due but that are not timely paid bear interest at 18%, which is almost twice the amount of Arizona's prejudgment statutory rate of 10%. So there is a penalty for not complying with the statutory timeframes. One other key function of the prompt pay statutes, and I didn't put it in the slide, but it is the ability for a contractor or a subcontractor to either suspend performance or terminate a construction contract for an upstream party's failure to make timely payments. And the statutory provisions regarding suspension and termination for in situations of untimely payment can be found in ARS 32-1185A through D. And I'll touch on each of those briefly. Pursuant to 32-1185A, a contractor may suspend performance under a construction contract or terminate a construction contract for failure by the owner to make timely payment of the amount certified and approved pursuant to section 32-1182. That's the statute that talks about the timing requirements. In order to do that, a contractor shall provide written notice to the owner at least 7 calendar days before the contractor's intended suspension or termination, unless a shorter notice period is prescribed in the construction contract between the owner and contractor. And if a contractor does suspend or terminate pursuant to this provision, a contractor shall not be deemed in breach of the construction contract. So that's an important requirement, and it gives contractors in dealing with the owners and a mechanism for them to enforce payment if they're not behind. Now, I will say that it's important that anyone thinking about terminating a construction project terminating a construction contract on a particular project, consult with an attorney before they do so. This is can be a particularly precarious situation, and you want to make sure that you're getting solid advice before you go down that road. But 32-1185A gives contractors that right to suspend or terminate, providing that they provide the requisite 7 calendar days notice. Similarly, 32-1185B provides that a subcontractor may suspend performance under a construction contract or terminate a construction contract if the owner fails to make timely payment of amounts certified and approved pursuant to the Prompt Pay Act for the subcontractor's work, and the contractor fails to pay the subcontractor for the certified and approved work. In that instance, the subcontractor shall provide written notice to the contractor and the owner at least 3 calendar days before the subcontractor's intended suspension or termination, unless a shorter time is prescribed in the construction contract between the contractor and the subcontractor. So again, this covers a situation where the owner fails to make timely payment of amounts certified and approved, and if that is the case, then the subcontractor, even though they're not in contractual privity with the owner, can terminate or suspend if they provide the 3-day notice, and that is in 32-1185. And I guess before I get into the last component, I think it probably makes sense for me to go back and address this language about certified and approved. That is important language in the prompt pay mechanism. In the slide that we're on right now, I talked, and in the previous slide, I talked about the owner has 14 days to certify and approve or object in writing to a contractor's invoice. And what happens if the owner does not respond either in writing or given an affirmative approval of the invoice within that 14-day period, it's deemed as a matter of law to be certified and approved. So if you are an upstream party, you want to be very careful in reviewing those invoices and realizing you have the time period prescribed by the statute, whether it's a public sector project or a private sector project, and be mindful of those deadlines to object to a pay application. And the same thing for folks downstream. Certainly, if you're a subcontractor, or if you're a general contractor and you're receiving invoices from subcontractors or suppliers, you want to make sure that you are reviewing those in detail and objecting before you submit those upstream to the owner for approval and payment. And you see this happen quite a bit, and it's really a misunderstanding of the way the Arizona prompt pay statutes work. You'll see on particular projects where general contractors will get copies of subcontractor or supplier invoices. They will send them upstream to the owner, and the owner will certify and approve those amounts and then make payment back to the general contractor of the amount certified and approved, which will include the relevant subcontractor and suppliers invoices. And then at that point, the general contractor sometimes will say, wait a second, we have a problem with the work that was done, or we have a problem with the materials that were delivered, and so we're going to hold back money. Well, pursuant to Arizona's prompt pay statute, that is too late in the game. Once the general contractor sends it upstream and gets it approved by the owner, and effectively they're certifying that it's approved at that point, and the money flows back down to the general contractor for that work, the deadline to object has come and gone. And so turning back to 321185 and the mechanism for suspension and performance, the second component for a subcontractor is that pursuant to 321185C, a subcontractor may suspend performance under a construction contract or terminate a construction contract if the owner makes timely payment of amounts certified and approved for the subcontractor's work, but the contractor fails to pay the subcontractor for the certified and approved work. And this really gets to the instance I was just talking about, where the sub's pay application or the supplier's payment application will make it all the way up to the owner, and payment will be made to the general contractor for that, and then there is a decision to withhold monies at that point. In this instance, so in the instance of the owner paying the general contractor, but the general contractor not paying the subcontractor shall provide written notice to the contractor and owner at least 7 calendar days before the subcontractor's intended suspension or termination, unless a shorter period is prescribed in the construction contract between the contractor and subcontractor. So again, that is a powerful remedy that both contractors and subcontractors have with regard to and helping enforce the prompt pay. Is they have the statutory right to suspend performance if the owner or general contractor, depending on the situation, are not complying with the prompt pay statute. And if they follow the notice requirements, and I will not dive into detail, but I will mention there's particular methods which these notices have to be given. If those are complied with pursuant to 321185, then the party who hasn't been paid will not be deemed to be in breach of the construction contract. And so moving on to our next slide here. This gets into the issue I sort of just jumped ahead and covered, is the obligation to accept or reject a contractor or supplier's invoices arises when the invoice complies with both statutory and contractual requirements. So again, I talked about the situation where it's important for the upstream party when they're receiving invoices to make sure that they are reviewing and approving those. However, pursuant to the Prompt Pay Act, there is a technical requirement that they have an obligation to accept or reject a contractor or supplier's invoice when the contractor or supplier's invoice complies with the terms of the contract. And so it means if the contract specifies that invoices or payment applications should look a certain way, then the invoice or payment application has to look that certain way, and then it has to comply with the statutory requirements. So when those things happen, that's when the obligation is triggered for the upstream party to review and approve within 14 days or 7 days, depending on the particular project. We talked about situations where an owner or upstream contractor may want to withhold payment for a particular portion of a specific invoice or the entire specific invoice on a construction project. And generally, the Arizona's prompt pay laws provide certain circumstances when that is appropriate. So this slide that I'm looking at here talks about those circumstances, and it provides the situation where it provides the circumstances where a contractor or an owner may certify or may object to or disapprove of an invoice. So the first instance is unsatisfactory job progress. Second instance is defective or disputed work or materials. Third is failure to comply with the construction contract. Fourth is third-party claims or failure to pay suppliers. Fifth is damage to the general contractor or other trades. And sixth is reasonable evidence that the contract cannot be completed for the contract price. So these are 6 of the most prevalent and statutory identified reasons for disproving of lower tier providers' invoices. And again, as the upstream party, you want to make sure that you are objecting to the invoices in a timely fashion, and you want to make sure that you're objecting in writing. So Arizona's prompt pay laws in some are a topic that we could spend a great deal of time on. I know the idea behind these webinars is to keep our talks short. So that is a brief overview of Arizona's prompt pay statutes. And with that, I'd just like to say that, again, as I mentioned during the talk, that Arizona construction law is full of detailed technical requirements and exceptions. And this presentation cannot substitute for specific legal advice. And if you're facing, again, any issues relating to mechanics liens, bond claims, or Arizona's prompt pay laws, please consult a qualified attorney, especially if you're in a situation where you're thinking of potentially terminating or suspending work on a project. It's really important, if you're going to go down that road, that you make sure that all your ducks are in a row beforehand. So again, that is just a brief overview of Arizona's prompt pay statute. Certainly is a topic that we could dive into and discuss in great length, but I will save that for another day. And with that is all I have for today.
Wonderful. Thank you so much. If you want to go to one of our last slides, our contact details are on this one. If you have any questions, feel free to ask. So far, we don't have any questions, but once in a while, someone will say, oh, you know what, I forgot to ask this on the webinar. So feel free to send us an email or call us at any time. And I wish everyone a very Merry Christmas, a happy and healthy New Year. And Kevin, thank you for a fabulous year of webinars.
Thank you, Ariella. happy holidays to everyone. Wish everyone the best.
Thank you.